contempt, set bond at $1,000 cash in each case. I believe last Friday, I found out about this on Monday. The defendants apparently presented themselves at the jail on August 22nd, posted $1,000 cash bond in each case, and were given a notice to appear for today for the show cause contempt in file 25040CZ. Plaintiff Township has filed a brief in support of a motion for preliminary injunction, actually requesting a permanent injunction, and file 25533CZ. These are two separate parcels of property. 25040CZ is 30158 Marsh Road. I believe the property known as Mama's House, which has been in operation for some time. The second case, 25533C, has the CZ has the same addresses, but it is a different parcel of property very near the other property on Marsh Road.
It actually has a separate address.
Adjacent to, what is the number?
30246 Marsh Road is the 533CZ case.
All right.
Now the Yoders live at 30158.
All right.
That's their address.
This is adjacent. All right. Now preceding all of this, all right, we'll get a little background. This matter has been pending before Judge Stutzman, and he's had several hearings in this matter. Judge Stutzman is a circuit court judge, and this matter was filed for hearing in the circuit court. Judge Stutzman made some rulings and issued these two bench warrants. Sometime after the bench warrants were issued, I was assigned by the Supreme Court to hear this matter. Judge Stutzman has disqualified himself for reasons that are known to him. And he asked me, he actually called me while I was on vacation and asked me while I would take this case. And I said, yes, I would. So Mr. Thornton has filed a motion to, I guess, reassign me or disqualify me under the theory that the matter should have been assigned to a circuit court judge. And so we have to deal with that before we deal with anything else. Once the order of disqualification was entered, Judge Stutzman signed it, Judge Pattison signed it. I don't remember whether Judge Kane did. I had already agreed that I would take it. Mr. Thornton, you're aware of this. St. Joseph County is part of a concurrent jurisdiction plan. That was entered on January 16th of 2013, and I'll provide you with a copy of that. And the concurrent jurisdiction plan indicates that the benches will share obligations. There is a statute 600.8304 regarding jurisdiction. A district court, in a district court district, which the district court is affected by a plan of concurrent jurisdiction adopted under Chapter 4, the district court has concurrent jurisdiction with the circuit court or the probate court, or both, as provided in the plan of concurrent jurisdiction. So just before you folks all came in here, I did a personal protection order matter, and I've done dozens, maybe hundreds of them. Those are circuit court matters, and we are all cross-assigned under our concurrent jurisdiction plan, And all 4 judges actually do personal protection orders. And I do my share, and I had one just a few minutes ago. On a number of occasions, I have covered circuit court matters in criminal disqualifications. I'm the primary backup for Judge Stutzman if he has a case in which he has to disqualify himself in a criminal case. So those are felonies. I've handled a number of those. I'm also his primary backup in zoning cases. And he's had several occasions over the years where he's had to disqualify himself in zoning matters. He disqualified himself in Lockport Township because he lived very near where the property at issue was. Recently disqualified himself. He moved to Fabius Township. And they had a complicated matter regarding solar farm. And he was disqualified. And I was assigned by the Supreme Court and our chief judge to hear the matter. So Mr. Thornton has cited some of the case regarding that, but Mr. Thornton, I do not believe it would require that I not be eligible to handle this case. I'll ask you if you have any other comment, but it's my intention to deny your order to reassign a judge. What would happen is it would then go to the next judge, who would be Judge Pattison or Judge Kane, who would know even less about this than I do. But I don't feel like I know less. As you know, we do lots of zoning cases of all shapes and sizes. And so it's my intention to deny your motion, but is there anything else you'd like to place on the record?
I appreciate the court providing me with a copy of the concurrent jurisdiction plan.
Do you have one yet?
I do.
Okay,
I
yes,
do.
so I think you
Have
said that.
So not sure I agree with the whole concept, but I understand the law. I've read it and read the concurrent jurisdiction plan. I understand it and understand that it provides that this can happen. Before Your Honor actually rules, though, I would just like to inquire because it does appear that Judge Stutzman said he had a conflict. Judge Pattison has indicated he has a conflict, had some knowledge or had spoken with the Yoders or their friends or both. On behalf of the township, I would just ask if Your Honor feels like there's anything that he knows or has been introduced to that would cause a conflict for Your Honor in this matter.
Well, that's a fair question. In the last case, I represented that I was going to dinner at Farron Hall shortly after our hearing. That was an issue that I raised myself. The answer is no. I know very little about this. I was at a county commission meeting when a number of people got up and spoke at the commission meeting about this issue. And that was the first I even heard of it. I don't know any of the parties. I know very little about it. I have not discussed it with Judge Stutzman, other than when he called me and asked me whether I would accept the assignment. So no, I don't know the facility. I've never had a case involving Mama's house to my knowledge. I don't know Joanne Yoder. I don't know Alfred Yoder. Lord knows I would be more than happy to foist this off on another judge down the line, but I don't feel I have justification to disqualify myself. So for the record, I don't know the parties, know very little about the case. In fact, I was totally uninformed when the parties were at the commission meeting speaking about it. I asked my administrator, she had some knowledge of it. But so the answer is no.
And I accept that. And so I'll just let the court make its ruling on my motions.
All right, I will do a formal order denying your motion in each case. So that's our first order of business. Our second order of business is to deal with the bench warrants. because I didn't know anything about this case, I had to familiarize myself with the file. And so I spent some time going through both files, 25040CZ and 25533CZ. Things are mostly done in the 25040 case. Judge Stutzman entered the judgment of permanent injunction on, can't read it, March 13th, I think it was. So that case has been decided. However, there was a show cause and then there was another show cause. And he issued 2 bench warrants. And then I was confused because the bench warrants were issued by Judge Stutzman and the clerk on, I believe it was July 7th. And the Yoders were personally served by Sergeant Morse from the Sheriff's Department later in July. At the time they were served of the notice for this hearing, they were open bench warrants for their arrest. I had a question of why weren't they arrested when they were served with the warrants? And I don't know that I got an answer to that. I don't think they wish to have a confrontation. I think there'd been some discussion about having them present themselves in the warrant, but a sheriff's deputy had personal contact with the defendants while the bench warrant was in effect, but it was not served.
My understanding is Bruce Morris doesn't conduct arrests anymore.
He does not, but he would. He doesn't. I don't want to. He does a wonderful job for us, as
Yes,
you know.
he
He
does.
handles our service, and he makes my life much easier by being so competent and professional. But at any rate, he is still deputized by the Sheriff's Department. Anyway, so eventually the Yoders presented themselves at the jail on Friday the 22nd. We're given notice to appear today, and they're not here today. They posted $1,000 cash bond, each of them, and filed 25040. And there's a notice from the sheriff to appear today at this time and date, which is good because we were already scheduled to be here today at this time and date.
I wasn't aware that anything had been set for today for that particular issue, but
Yes, let me see. I think I copied the notices. They were given notice by I can't read the deputy's name. I guess I saw the original copy for August 29th at 1400 hours, failed to appear on the show cause. So they aren't here now. A number of other people are here. So I can't arraign them on their bench warrants because they aren't here. Someone was here earlier this afternoon, and these were signed and date stamped August 29th. I received what I is entitled response and filed 25040 and uh 25533CZ. So the allegation is that the defendants were in civil contempt for failing to appear for an order to show cause, and now they fail to appear pursuant to a posted bond for an arraignment on the show cause. Mr. Thornton, what's your thought in that regard?
my thought first with the responses that have been filed today. As the court has pointed out in 25-040 CZ, there really isn't anything to respond to in that. So I don't know what the court wants to do with that. With the response today attempted to be filed in 25-533 CZ, the
Well,
orders are.
let's stick to 40 for a minute, because that's where the bench warrants are.
Okay.
I'm unhappy that they're not here. I never met them. I don't know them. I don't have any prejudgment about it. Judge Stutzman issued those bench warrants. There was criminal or civil contempt. My inclination is to issue a bench warrant for criminal contempt for failing to appear pursuant to a posted bond and set bond at none. No bond until I see them. They will appear at the jail or be arrested by the sheriff and be held in custody until such time as I can conduct an arraignment. I don't like somebody poking me in the eye with a sharp stick. Judge Stutzman ordered the bench warrants. They did appear and present themselves. They posted $1,000 of cash in each case. Civil contempt is punishable by up to $7,500 in fines, but not a criminal punishment. Now they failed to appear pursuant to this. Now, this is a civil contempt in a zoning case. The Criminal Justice Reform Act changed the rules a little bit as to bench warrants in criminal cases. As a rule, we are to give 48 hours of grace before the bench warrant issues in a criminal contempt case. Fail to appear on a bond. And so my inclination, Mr. Thornton, is to issue 2 new bench warrants with no bond until they're seen by a judge, namely me. And give 48 hours. In fact, I would start the 48 hours on Monday. So they'd have until 5 o'clock on, well, Monday's a holiday. I would grant them until 5 o'clock Wednesday, September 3rd to appear.
And I'm fine with that, Your Honor. In that case, as the court's pointed out, we do have a permanent injunction. The birthing center is not supposed to be in operation, and it's my understanding it is still being operated.
We haven't taken any testimony regarding that, but that would violate the permanent injunction and subject them to further contempt if it is still being operated. Anyway, I'm going to issue a bench warrant for Alfred E. Yoder for failing to appear pursuant to a posted bond in a contempt matter. I'm going to set the bond at no bond until such time as he sees the judge. He has until Wednesday, September 3rd to present himself at the court. I would order the exact same matter and Joanne Ann Yoder. I find she's in contempt for failing to appear at this hearing. It's not accidental contempt, it's willful contempt. They don't recognize the jurisdiction of the court. We have a fundamental disagreement on that subject. But if they don't appear this time, they're going to sit in jail until such time as I can see them. So 1 for Alfred E. Yoder, 1 for Joanne Yoder. All right, so that finishes 40 CZ, 2540 CZ. That's the case that's done with a permanent injunction. That's on Mama's house. That's the bench warrants were in that case. The other case that it needs to be addressed today, which was set for hearing, is 25533 CZ. That is the other property where something was being constructed, I believe, to supplant or replace the facility that was used for Mama's house. The lawsuit was filed on July 22nd of 2025. The defendants filed no response. We'll talk about today's response in a minute. And the clerk sent out a notice of entry of default on August 22nd. They waited 31 days rather than 21 days, sent out a notice of default. So the matter was set for hearing today. They did not file a response in a timely manner and would be subject to the entry of a default, granting the relief requested by the township. I received today, in that case, something entitled response. I read it. I'll accept it for filing. It doesn't meet the standard of a legal answer to a civil complaint. It's got some archaic language. It's got a fingerprint.
May I speak on that?
Yes.
Being in default, it's my understanding under the court rules that an answer cannot be filed and accepted by the court until the Yoders would file a motion and show a meritorious defense through affidavits or testimony.
Well, what we're going to do, I'm going to grant your default. Now that we need a default judgment. The entry of the default is in there. What we would need to do is,
After that guy, was that filed in my office?
It was stamped by Gina Everson.
I don't know if it was filed.
And it doesn't. I wanted to make sure that it wasn't. It's titled a response, so my clerks would not have put it in as anything other than a response. So I would not have used that as an answer.
In district court, we're much more flexible. We take handwritten answers, as you know, in civil stuff and grant the people a day in court. Well, this, whatever it is not filed in a timely manner. So we have a notice of entry of default signed by the clerk on August 22nd. What I need for you to do is move to enter the judgment of default as to each defendant. Your pleadings in that case. Now, the motion for today is for entry of a preliminary injunction. And you did a good job in your brief of setting out the standard for preliminary injunction and what it is. And it's not to be granted lightly, but it's based on the likelihood that the plaintiff will prevail in the ultimate hearing. In your actual motion, that's filed with the court, the relief request that on page 9, you request permanently enjoining the defendants, agents, servants, assigned successors in interest, or those active in ANSIC concert or participation with them from using the subject property as a birthing center. This is the adjoining property. So the complaint requests a permanent injunction. They have not responded to that in a timely manner.
I can address this, Your Honor.
Yes.
What I'm going to request today is that pursuant to Court Rule 2.111 E1, the detailed allegations in the complaint, and they are detailed, are now admitted by the defendants due to the default. And the defendants cannot proceed under with the action until the defaults are set aside under Court Rule 2.603A3.
And I agree with that.
And
so what we need to do is your pleadings stand as accepted because there's been no answer, which would, and your pleadings include your signature as attorney for the township. Once we enter the judgment, and you're asking for the permanent injunction?
Well, I was asking today for the preliminary injunction to be entered based on the fact that they're not here to defend, they're in default, and all those, the allegations in the complaint and the supporting documents are at this point admitted by the defendants. What I intend to do then is, let's see, provide under 2.603B1 of the default court rule. I may not be required to do so, but on the just being overly cautious, I will prepare a permanent a default judgment with permanent injunction, which I have not done yet, but will soon. And I would submit that, send notice to the Yoders, and then set that for hearing and have the court enter it at that hearing.
All right, so what you're asking me to do by default today is enter the preliminary injunction.
That's correct.
All right, I will so order as requested.
And Your Honor should have a proposed preliminary injunction order.
I have the brief and I have the judgment. Let me see if I have the order in here. Do you have a copy?
I do.
By default, the court finds that the defendants failed to file a response in a timely manner to the lawsuit, which was within 21 days. They've also failed to appear at this hearing, which also subjects them to default. This is the 29th day of August. This preliminary injunction order states the court makes the following findings. I'm going to have to change the name, but Colon Township is likely to succeed on the merits of its claim against Alfred E. Yoder and Joanne Yoder with regard to the alleged violations of Michigan's construction code as cited. Defendants are the owners of the following described real property, and that is the subject of this case, and the property is described by legal description in the order. It's also known by a common address of 30246 Marsh Road, Colon. A building being constructed on subject property without building permits and inspections by qualified building inspectors represents a dangerous situation that could easily result in irreparable harm to persons using or visiting the building, including emergency personnel. The court does lots of these. Routinely, we have zoning violations where people are building things without a permit, garden sheds, additions to their house, garages, which are in the right of way of the road. That's routine zoning matters we do in the district court. I'll continue to quote from the proposed order. The plaintiff has no adequate remedy at law. The risk of harm that would exist if the preliminary injunction were not granted outweighs the inconvenience to the defendants caused by granting the injunction. the public interest is furthered and not harmed by the granting of the preliminary injunction. The applicable law cited in plaintiff's brief and support motion for preliminary injunction authorizes injunctive relief under the circumstances. And as I mentioned, Mr. Thorne filed a brief which was well cited with the facts and the law. It is hereby ordered that the above findings of fact are hereby incorporated and made a part of this order. Plaintiff's motion for preliminary injunction is granted. The defendants and their officers, agents, service employees, attorneys, assigns, successors in interest, or anyone in active concert or participation with the defendant are enjoined from performing any further work on the interior or exterior of the building being constructed on the subject property unless a valid building permit is issued for the building by plaintiff's building code officials, and the stop work orders that have been issued and posted are rescinded by the plaintiff's building code officials. And occupying the building on the subject property or allowing anyone else to occupy the building unless written authorization to do so is obtained from the plaintiff's building code officials. Colon Township shall cause a certified copy of this order to be posted on the front door of the building of the subject property within 10 days of the entry of this order, and no one shall remove the posted copy of this order from the front door unless and until its removal is authorized by the plaintiff building code officials. This order will remain in full force and effect until this court specifically orders otherwise. This property is posted, and there's a copy of it in here, with a prominent no trespassing sign. And arguably posting this on the front door of the property. So you may post this on the trespassing sign.
Right.
Well, you won't have to enter onto their property over their objection. There's a trespassing sign of some elaborate detail in front of the property.
Or would the court entertain adding to my order that we be permitted to go on to post it on the front door with a
well,
peace
it already
officer?
says that, but I don't want a confrontation.
Well, I would request a peace officer from the.
All right, well, then I'll leave it as you drafted it. Signed effective August 29, 2025. This order is entered by default. Failure to answer in a timely manner and fail to appear for the hearing. And Mr. Thorne started to speak to this. When a default is entered, the plaintiff can move to have the default set aside. I believe it's within 21 days of the entry of the default. And in order to do that, you have to show good cause for failing to appear or answer, and you have to show an affidavit of meritorious defense. And this comes up all the time in my court. Lay people are being sued by an insurance company or a hospital or an auto lender, and they get defaulted and they don't understand what's going on, and they file an answer in a handwritten letter, but it doesn't rise to the level of the statute to set aside a default. You need just cause for failing to appear at the hearing, and I don't know what that is, because they aren't here, and as I said, I'm not very happy about that. And secondly, they have to show an affidavit of meritorious defense. The document entitled response, I make no finding on whether it is an answer, appropriate answer. Whatever it isn't filed in a timely manner. And secondly, they aren't here to address it. You don't swing by the courthouse 5 minutes before the hearing, drop off a vague pleading, and cover your bases. That's not how it works. they were willing to present themselves on the warrants and post the bond. So I'm disappointed that they aren't here. I had hoped to engage in some sort of dialogue. In true point of fact, they need a lawyer. They need a lawyer who's licensed in the state of Michigan. They're gonna end up in jail. There may be legitimate defenses to this. There may be issues that could be explored by competent counsel. They have their own reasons for choosing not to retain counsel and be represented by themselves. But in the humble opinion of this court, they could benefit from competent legal advice because they're going to end up in jail. They're going to end up in jail unless they appear by next Wednesday at 5 o'clock, because they're going to sit in jail until I get a chance to see them. They were ordered to appear by Judge Stutzman. They failed to appear twice. He issued a warrant for their arrest. They were given a notice to appear today, and they gave me the same discourtesy they gave to Judge Stutzman in failing to appear. So I can't even talk to them. So let's recap. I've denied the township's motion to disqualify myself because there is a concurrent jurisdiction plan in place. I handle these matters in my own court routinely. This is not outside the province of cases that I regularly do. So I'm going to do a written order denying that in each of the two cases. Secondly, I intended to arraign the defendants on the bench warrants in 25040CZ, but they failed to appear. So I issued new bench warrants with no bond. The defendants are allowed 48 hours, in this case, a little more than that, until next Wednesday at 5 o'clock to present themselves either at the jail or at the court. The bond is none. Third, I've granted plaintiff's motion to request a preliminary injunction and filed 25533CZ. Mr. Thornton intends to file a further notice asking for a permanent injunction, and again giving them an opportunity to respond. But until further order of the court, the preliminary injunction is in place to prohibit any further construction or occupation of the second building. Mr. Thornton, is there anything else we need to do here?
No, I will see the court, Your Honor, Secretary, about getting a date for the next hearing for that proposed default judgment.
All right, very good. It's easier than it was with my schedule, vacation schedule, the judicial conference. We're good now till deer season when Judge Pattison is gone much in November, but we're here for the duration, so it should be easier to find a place to put this than what we had for today.
Okay.
All right, this is a public courtroom, and I appreciate that. This matter is also being live streamed. You can watch it on YouTube. It's important to have a public courtroom that people can come into and sit and see what happened. We just saw what happened. You may not agree with it, but it wasn't done in secret. So we'll see how we proceed further. Thank you all for being here today and your decorum.
Thank you, Your Honor.
I've signed the order. The clerk will prepare it, and I'll do my other two orders denying your motion to disqualify.
Yeah, I'll
Prepare the bench warrants.
What's that?
You're gonna prepare the bench warrants?
Yes, we should make that. I'd ask you to prepare the bench warrants as the last.
Okay. Okay, I will do that.
And so, just so that I'm clear, so.
Just a minute, let me go off the live stream and the record. All right, we're completed this matter. Thank you.
Mr. Burton, James,
Okay, any,
and thank you, Your Honor, Daniel Best, B58501, and we have the plaintiff, Cheltenham Hemphill.
Good afternoon, Your Honor. Benjamin Folger, Greg Crockett, on behalf of defendant James Burton, standing to our right. If it please the court, our intern Talia Epps is present as well.
thank you. And today was the date that was scheduled for non-jury trial. We're not able to resolve it, is that correct?
That's correct.
Oh,
Oh, sorry, why am I answering? I'm so sorry.
it's probably habit.
Sorry.
That is correct.
Okay, so we're ready to proceed.
Plaintiff is,
Okay, any preliminary matters before you proceed?
not the plaintiff, Your Honor.
You can call your witness.
Very good. Your Honor, I call Colleen Cheltenham. It helps if I know how to pronounce my client's name to the stand.
Do you solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under penalty of perjury?
Yes.
And you can have a seat.
Ms. Cheltenham, can you state your name and spell it for the record?
Certainly. Colleen Cheltenham, COLLINE,
And are you familiar with Mr. Burton, James Burton, the defendant in this matter?
I am.
And how are you familiar with him?
Mr. Burton came to my office in, I think, April of 2022 and retained me as counsel.
Okay. And can you just walk through the routine process?
Sure. What we do first before we do retention is we meet the client and do a free consultation. I don't recall the moment if that was in person or over the phone, but one of the two ways is how I met with James. And during that consultation, we discuss the case, we discuss maybe the process, and then our retainer fee and hourly rates. And then after that, we send a retainer fee agreement and electronic pay link to the potential client for them to sign at their will and then pay the pay link at their will.
Very good. Handing you what is labeled as plaintiff's exhibit A. May I approach the witness, Your Honor?
You may.
Can you describe that document?
Certainly, this appears to be my retainer fee agreement with Mr. Burton.
And what were the general terms of that agreement?
The terms of the agreement is, one is we laid out a payment plan for the retainer fee itself, but we have the retainer. I don't know how much detail you want me to go into. I'm sorry. Do you want me to go through the exact terms or just generally?
I was hoping the more specifics, the retainer amount, the agreement, that sort of thing.
Okay.
I mean, the agreement for payment, excuse me.
Thank you. So on this particular retainer fee agreement, we had a retainer of $8,000. We had a down payment on signing of the retainer of $3,000. And then we had a breakout of $1,000 payments through a schedule in the retainer fee agreement. So Mr. Burton could meet that $8,000 retention fee. And then on the next paragraph, it gives our hourly rate for me, for myself, my associates, and my staff. And then continued on the second page is under paragraph 4, it tells us that he's going to be billed hourly and bills will be sent monthly. Paragraph 5 explains that retainer fee breakout, and it also explains what happens after that retainer fee is depleted. And then paragraph 6 tells us what he will be billed for, the types of services and things that he will be billed for. Paragraph 7 is just a reflection on us submitting statements each month, and that those statements would reflect all activity and expenses incurred. And in paragraph 8 is if the retainer fee is depleted, we'll bill monthly. We again articulate that. And any unused funds would be returned to the client. Paragraph 9 is that we may withdraw if 2 or more payments are missed, or if there's a balance due of $5,000 or more. Paragraph 10 is that we're granted a lien in any property settlement which wasn't valid in this case. This was it was a guardianship issue that turned into really a custody issue and parenting time issue. And paragraph 11 tells us that we may designate other legal assistants and attorneys as appropriate. Paragraph.
Well, let me stop you. I don't.
Yeah, that's okay.
That goes beyond the payment.
Okay. I
I would like you to, identify what paragraph 21 provides for in the agreement.
Paragraph 21 provides that the agreement and its terms cannot be modified unless modification is in writing and signed by both the attorney, which would be me, and the client, who is Mr. Burton.
Was the retainer fee paid?
It was never paid in full. My recollection is that we received a $3,000 down payment as appropriate. And then there were 2 other $1,000 payments received from Mr. Burton.
Let me ask you, does Cheltenham law, do you maintain business records?
We do maintain business records.
Okay, and is the information contained in those records entered at or near the time of occurrence?
Yes, they are.
Is the information entered with the person responsible for entry of that information into the records?
Yes, it is.
And is it the ordinary course of business of Cheltenham law to maintain those records?
It is in the ordinary course of business to maintain those records.
And I'm handing you a packet that I have labeled as Exhibit B. And can you describe what that is?
Exhibit B appears to be a packet of the various invoices that my office sent to Mr. Burton. Looks like June of 2022 through, one moment, I'm sorry, May of 2023. This exhibit C that's behind here that we can hand it.
Oh, yeah, I'll hold on to that for now. And I would apologize, Your Honor, I did not ask to approach. May I
You're fine.
approach the witness?
Yes,
Does the court want me to ask to approach?
you're almost there anyways.
I was sort of thinking that, but I didn't want to say it out loud.
For court-appointed attorney to
so
ensure you have
what
an
are these
attorney
invoices?
at your next court date, okay?
What do they represent?
They represent each and every.
And,
finance that
anything
underlies
else to
those.
bond, Mr.
Yes.
No history, Judge. I was Detroit traffic and Romulus is a traffic matter. The other 2 matters, I could not find any information. However, given my experience of living in St. County, if they have a $250 bond, that's traffic.
It's
And that was
traffic.
services
Yeah.
rendered in accordance with the retainer fee agreement.
That's correct.
Request personal.
And
Ma'am, I see some traffic holds, but I don't see a significant criminal history. You need to show up for court, you understand?
Okay, yes.
So on the cases, I'm given on all 3 of them, you have a $1,500 personal bond, so you don't have to post any money, okay?
Okay.
And we'll send you notice of your court date in the mail. These are your bond conditions. You're to appear in court as directed. You're not to leave the state without permission of the court. You're not to commit any new crimes while released. You're to immediately notify the court of change of address or phone number. Ma'am,
Yes.
cannot possess or have access to firearms or other dangerous weapons while this case is pending. You cannot consume alcohol or illegal drugs. You may be subject to testing on demand. Ma'am, if you don't receive your court date in the mail within the next week or so, make sure you call the court so you don't end up missing a date and getting warrants, okay?
Okay, thank you.
All right, you're all set.
Thank you, Your Honor.
Good job, sir.
All right, thank you.
And throughout this, I note that there are listings on the last page of each individual invoice with a payment history. How describe going to the very last page has a payment showing the payment history Can you just describe to the court the payments that you received on this?
Sure, and I'm looking at the last page. Is that correct?
Correct.
All right, so what happens, there's a trust history on the last page. And there, underneath that, there is a credit history. So sometimes what happens is when we receive a client retainer, somebody may have assigned it to what's called a credit, and that is still deposited into trust. So that the very bottom line shows the credit deposit of $3,000 on 4/27/2022. Up above that, this is under the credit history, which this is underneath the actual trust history. And then there's a credit withdrawal of $3,000, meaning we withdrew that, we placed it into trust. And those funds are still held in trust. We moved it from this credit history to the trust history where it should have been deposited. And then up above that, there is the trust history. And then we have deposits, a trust deposit, and our payment from trust means we've drawn that from the trust account to pay the invoice.
Okay, and again, I thought you said you've received a total of $5,000. Did you apply $5,000 towards your bill, your company's bill?
So we did, but we didn't.
Yeah, Ms. Engen and Mr. Morris agreed to an adjournment, and I asked her, she said she thought 2 weeks would be sufficient.
September 12th, 2025, 1 p.m. Did you get him his lease?
Sir?
He wants a lease. So, yeah, you weren't here, but I have to call him for a lease.
Yeah, I have a note here that says need to email a lease to him.
Hamilton Crossing 2 versus Turbine Weatherspoon.
James Sink for the plaintiff.
Your Honor, Jill Bauer, on behalf of Ms. Weatherspoon, we have excellent news to report to the court. We have received funding for 100%. I have commitment letters from 2 funders, and so we're just waiting for those funds to be sent to plaintiff.
Has that information been sent to the plaintiff? Or
There you are.
no, it's okay.
Kind of multitask for these days.
I will tell you, Your Honor, while Mr. Fink is looking, we discussed a 3-week adjournment, and we think that the case will be dismissed before that because the funds will probably be received.
Her facts are generally correct, but not always complete. She was discussing a 3-week adjournment. I was talking about 2. And
Well, I would
Sorry
say
about
if you
that.
have the commitment letters, the motion that you sent in indicated that the balance could be cleared in 2 weeks. So.
Thank you, Howard.
Turn this matter to September 12th, 2025.
Your Honor, I'm going to be in Europe on that date.
Everybody in your office will be in Europe?
Well, Your Honor, we're very short-handed right
No,
now.
you're
Honor, we have a
No, you're not. The
I don't know
legal
what she's worried
services,
about.
they're all over the place.
And Ms. Weatherspoon is an Ypsilanti Weatherspoon. I don't think anybody thinks I'm gonna do something untoward to her.
And me either, so. I'm gonna set it on the 12th at 1 p.m. See if we get taken care of. All right, you take care. Have a good weekend. Hamilton Crossing 1 versus Keisha Franklin.
Jill Bauer on behalf of Ms. Franklin, Your Honor, who is also present.
Right. So where are we on this?
Your Honor, we're still trying to schedule an inspection of the stove. We think that the information from the inspection could be very helpful in settling the case. So we're asking for another adjournment until that can take place.
Who's going to inspect the stove?
We found we found an electrician who's willing to do it, on behalf of Miss Franklin.
So when's that gonna happen?
Well, we reported that back to the court last time we were here, and we have been trying to get a date and time to inspect the stove, and we just haven't been provided with one yet.
Can we just set it for a trial and hopefully the rest of the stuff will be done by then?
Final settlement conference, September 16th, 2025. 9 AM, that's in.
Your Honor, I'm gonna be in Europe on that day, and I really am the person that needs to be here for that hearing.
They're called summary proceedings, Your Honor.
No, I'm not going all the way to the end of the month. This was supposed to, the last adjournment we were here, they were supposed to. What's the holdup on the inspection? Yes, ma'am.
I called and asked them where was the stove. They had no idea. And they said, I asked them why they didn't give my lawyer a date, and they didn't have no idea either. And they knew that last time we went. That's why we adjourned it to now.
So somebody's got to find this stove to inspect?
They should have it.
Oh my gosh, you can't make this stuff up. All right, I'll make it the 19th. And
Still a final settlement conference?
no, it's gonna have to, I'm gonna put it on this docket, but I can give a quick final settlement conference if we don't have things going.
Okay.
September 19th, 2025, 2 PM.
Thank you, Your Honor.
Thank you.
Oh, and Your Honor, just for the record, I'm sorry, Miss Franklin paid her escrow. She wanted you to know that.
Thank you.
So I'll still come and put it in for this month coming?
Yes, yes, ma'am.
Yeah, can you tell me how much is in escrow?
It was ordered that she pay $55.
Yeah.
The receipt shows
And then you
$55.
still get on the first.
She's gonna
Yes.
be 110 next week, probably the second, because the first is off.
That makes sense.
Hamilton Crossing 1 versus Kristen Benson. Hello. What's your name?
Kristen Vincent.
All right. And what is plaintiff's claim in this case? Well, he looks for the number. Did you get the 1,000 paid?
So, no, I got a call from Miss Ballard last week, and she gave me a different amount that was owed, which was 1862. So I did get notified from Friends Indeed that they would give me 500, and from Peace Neighborhood Community 500 from them. So that would have been close enough to get to where I was on the payment plan. She sent me a letter they put a letter on my door that following week telling me that I had to pay again 2301 within 3 days or be out. So I was very confused. I couldn't get in contact with her until just yesterday around 4:30 PM, when she sent me basically everything, like almost like a ledger of everything that I owe and that the amount is correct. So now I have to basically reapply with the Friends in Need for the amount, because it was a certain amount that I had to get to get the assistance from them. But when she gave me the lower amount, that's what I thought I had to reach. So it was just a mix up, but I did come up with the 500 that was needed. I just haven't been able to drop it off. Just heard from her yesterday, just getting clarification on what was going on.
So you have 500 that you can pay to the landlord?
Yes, right now.
Okay.
My note says she's gonna pay 600 today and then we're gonna work on a COD. So I think a 2-week adjournment makes sense.
Okay.
That work for you, ma'am?
Sure.
September 12th, 2025.
Okay.
1 PM.
Now, if this is done before then, I don't have to come back.
Well, you want to see me?
Yes.
Um,
Do you want to put MCR 4.201J on the record?
I'll put that on there right now. Ma'am, if it ends up in a conditional order of dismissal, from the time that I sign it, you have 3 business days in which to think about that. If you believe that there's some right you didn't assert, some confusion on your part, or some mistake that you've made, you'd have to file a motion with the court within 3 days of my signing that.
Okay.
Okay?
Okay.
Understand that?
Yes.
All right, fine.
Thank
You don't want to see me? Bye. No.
Have a good weekend.
You too. Court does call the case of Hamilton Crossing 1 versus Christina Franks Hatter.
James Sink for the plaintiff.
Hello.
Christina Franks Hatter.
All right.
Her total is 936.
Yeah,
Sure.
that's his father, Tommy Hatter. That's their brothers.
All right. So how are you gonna get this paid?
Tanisha granted me the COD from last time on the 15th when I came from Strong Future.
I gotta know what this is. We'll do a COD. So
And so I have $75 on me today from Chase to put.
give it to me. I'll lose it.
All right. You have a COD there?
No, I don't have one, but we'll do one.
Okay. So I'll adjourn this out a couple weeks to the 12th.
email
Let's
address.
give you time to get that in.
Spelling counts.
2025 at 1
It's my
p.m.
first and last name.
Yeah.
iCloud. Just in case you can't.
Do you want to give her 4.201J? Thank you.
So ma'am, I'm adjourning your case out to the 12th.
Mhm.
There's going to be a COD prepared and be able to look it over and sign it. Okay, I wouldn't sign it if you don't understand it, but I'm going to advise you since there will be basically an order, you're not represented by counsel. You would have 3 business days after my signing to file a motion. If for some reason you believe that there's a right you didn't assert, some confusion on your part or some mistake, you have 3 business days to file a motion or to revisit it or set it aside.
Okay.
You understand that?
Yes.
All right, wonderful. You have a great weekend.
Thank you, you too.
Court calls the case of Hamilton Crossing 2 versus Veronica Whitsett.
Talk about times. Hello.
Hello, Miss Whitsett, how are you?
I'm well and you.
Fine.
I just made it.
What?
I said I just
Just
made
made
it.
it, man. Okay. What do you have her owing at this point? Last year, we had 786.
Yes.
We paid anything since then? Or-
I have not. They still haven't done any repairs. Management reached out to me.
Okay.
And like the phone kept hanging up. I don't know if it was her or me. And I haven't heard anything from them since then. They came and put like a little note on my door that they were coming to change the porch lights, and they did that, but no other repairs have been made. And before I hung up with her, we talked about the hole in my bathroom from where they changed the lights and they didn't repair that. We also talked about my screen door that has fell apart, and I have been injured from the door, and I really can't go out on my back porch because the whole bottom of the door is missing. So if I do go out there, I have to shut the big door. You know, it's just the whole thing. So, and it was some other little things that I had asked for. My stove goes in and out. I asked them to come look at that, and I've been there for over 10 years, and I wanted paint. I didn't want them to
How much
paint.
is your monthly rent?
My monthly rent is $580. So the amount that's here now should be court fines and the $50 late charge, plus the $580.
Right. But what we're gonna have if I adjourn this out, which you might have to do, there's $580 that would need to be paid,
Okay,
all right?
yes, sir.
If, what I'll do is I'll order that you pay escrow of $580
Mhm.
on or before the 5th of September,
Okay,
okay?
yes, sir.
Then I'll adjourn this matter out to the 12th, September 12th,
Okay,
2025 at 1 PM.
okay,
Okay?
sounds good. Thank you so much. You have a wonderful day.
Do the same. And you. Hamilton Crossing 2 versus Brandy Colston.
James Fink for the plaintiff. 507.75 is the total.
Hello, 775.
Hi,
Hello.
how you doing?
Okay. 507.75. How are you gonna get that paid?
You say how much?
507.75.
Okay, right. Well, that's the problem because last time I came to court, remember, it was 547. It was 557.57. So when I did my SCR or whatever, that's what I put in. So now I have to redo it for the 507. It was
The
5.
amount last time that I was given was 557.75.
Right. So now they gave me amount of 507, but I had already did my paperwork for the 540, whatever, the other 5 something. I got denied for the SCR, so I went through Hawk. But the problem is the numbers don't match up.
Well, that looks like it's a late fee. That was applied at one point, but not applied.
Yeah, and they don't compensate with me either. I'm trying to call these people at Hamilton Crossing. She gave me an extension number to get in touch with her, but the phone just rings. Just ring, 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 ring. I'm like, I don't know what's going on, but it would be nice to have a communication with Hamilton Crossing. It would be nice because I always pay my rent all the time. I don't have no problems. Like,
Okay, so
I pay my rent. So now I have to call Hawk again and give them the
a lower
507
number,
paper.
which shouldn't be a problem with it. I mean, okay.
Right, I don't know, that's how I feel. I
What's your
don't know.
monthly rent?
So you have an application pending at Hawk right now?
Yeah, somebody supposed to be calling me back. I got denied for the SCR anyway, so that doesn't matter if it's 507 or 550, but I got denied.
Rent.
Huh?
How much is your monthly rent?
My rent is 0 for right now.
Okay.
What,
very good.
because my daughter moved out, so that's what's going on.
Then I'll adjourn this out to September 12th, 2025 at 1 PM. Okay?
Okay, thank you. Have a good day.
You too. Court calls the case of the Glencoe Hills versus Eritza Herrera. Hello. What's your name?
Yarisa Herrera.
And
Talk to the judge. 96.36.
1296.
300 less than it was.
Yeah. Okay. All right. How are we working on getting this paid?
Well, I talked to the manager at the office yesterday. That's how I got the credit. We're still working with the Section A and the VA, trying to get my income adjusted because I lost that 710 a month and they still haven't calculated that. My specialist, she's been out of the office. We found out yesterday, so she's back and the manager at the landlord's office has been in contact with her. So they're trying to work this out and
From the VA or?
no, for my Section 8
For
to
your
be
Section 8.
adjusted
Okay.
because they still have me at that original income.
And she said the manager has done that. So how much do they have your monthly rent at now?
My portion is 540.
Like
Okay.
20 plus some expenses.
Yeah, I have a carport that I pay $20 for, and then some
Gotcha.
utilities. Now,
So you're gonna be able to pay that for September?
yes, I've been paying my portions. The
It's,
problem is that those fees and then coming here,
gotcha. So what I'm gonna order you to do, I'm not gonna have her put it into escrow. I'm just gonna have her make sure that you make your monthly rental payment. Cause it's going down. Just because of where the numbers are going. Make your $520 payment to the landlord directly. Okay, for September. And then I'm going to adjourn this out to the 12th, 2025 at 1 PM and see if they can make any progress with your Section 8.
Know what you need to do.
yeah.
Okay.
Mhm.
Okay?
We're working on it. She did call me today, but I missed her call.
Oh,
I'm having like blood sugar issues, so I didn't see
Okay.
my phone ringing.
got it.
So Section 8 did call me. I just have to get back with her.
Okay,
So
All
I'm
right.
hoping it's good news from her.
okay. Then what we'll see the 12th and hopefully sooner or later they'll get it resolved.
Okay.
All right?
Thank you.
Take care. You have a
too.
great weekend.
You too. Thank you.
Outside Lakes versus Sarah Brown. Right here, okay. Sarah Brown or Jalen Brown? Take a default on this one.
Yes, sir.
Raise your right hand to be sworn. Do you solemnly swear or affirm testimony you're about to give will be the truth, whole truth, nothing but the truth, so help you God?
I do, Your Honor.
All right, go ahead.
This is an action for non-payment of rent. These defendants owe $1,327.88 in rent. The taxable costs are $214. For a total redemption amount of $1,541.88. This is a possession-only judgment. We request a default judgment with a writ to issue after the statutory period.
Judgment to the plaintiff, that is by default for possession, redemption amount in the amount requested with the writ issue in 10 days. Cause case of Gulfside Lakes versus Patrice Haywood. Oh, there she is. Okay.
Ms. Haywood always shows up.
I know, that's what. Hello, Ms. Haywood, how are you?
I have a note that says she's working with Hawk.
Is that correct? All right, then. Let me put this out to the 12th, 2025 at 1 PM. Okay? You have a great holiday.
Thank you.
Ms. Haywood.
Huron Vista versus is it Tashia Clark? Don't yell at me, because if I mispronounce your name, they're gonna say something. Call. What's the 12? Yes. Yeah. Thanks. Hello. All right. What's your name?
Tisha Clark.
All right. And where are we on this?
Shows $2,086.
All right. Ma'am, how are you intending on getting that paid?
Well, I was supposed to be on a forgiveness plan or something. And
Had they contacted, I think we were talking about it the last hearing. Have they contacted you at all?
I signed what I needed to sign, and they were supposed to, once I paid July, August and September's rent, they were supposed to pay the other, whatever the,
Do you have
whatever
10
the rent.
minutes?
Huh?
Do you have 10 minutes?
Yes.
You have passed this, Your Honor, if we get rid of get done with every other case,
All right.
I'll look at my emails and see what we can figure out.
Okay, I'll pass it.
That work?
Huron Vista versus Ms. Beth.
I was gonna see if you were gonna try it.
You know, I wasn't, because they yelled at me because I messed up somebody else's name today. And so I said, oh, boy.
It's okay. You said it right the last time. It's Giovanna.
I know, but even a blind squirrel can find a nut. I mean, I'm just, that's how that happened.
I completely understand.
State your name for us.
Giovanna Nesbitt.
That's exactly what I was gonna say.
See?
Okay. All right, where are we on this case?
Current balance is 2308. She made a payment of $700. Today, the 29th on Monday.
Okay. That's been applied to it, correct? Yes, it had to be. Okay, all right. So how are you gonna pay the rest of this, do you think?
I was also a part of the forgiveness plan thing that's supposed to be occurring after September 5th. So I kind of paid a little bit more so it can give me a head for September for now, but it's still the amount that's owed, which is the 12, is still less than my monthly rent.
All right, let me ask you this. Did you sign a conditional order dismissal?
No, I did not. I do have like the email from, I think his name is David. From when we had this conversation about the July, August, September forgiveness plan.
Right.
That's what I do have, but I didn't sign up. I didn't get nothing for a dismissal at all. They didn't talk to me.
All right. What do you want to do, Mr. Finn? You want me to pass it and let you look or adjourn?
So, although we won't be able to get them done today anyway, so why don't we put her and Ms. Clark over to the 12th.
All right. So what I'm gonna do is I'm gonna adjourn your case out to September 12th, 2025 at 1 p.m.
Question for you. Can I request with you right now to do it virtually, or do I still need to fill out that one form and then send it to you guys via email?
I'm supposed to have it every time, but I'll give you permission since these people around here keep messing your name up. I'll give you.
Your Honor, if we get the CODs done, do they even have to show up?
She won't have to. She should be good, but I just want to make sure. If the COD gets done, then you'll be good about you don't have to appear.
All right. That's good.
I understand what the program is and everything, okay?
Okay, thank you.
That'll take some burden off of me when I see your name and I'm like, oh, no.
Well, good. We'll both have a great day.
All right, you take care. Have a great holiday.
You as well. Thank you.
Mhm. And ma'am, Clark, I'm going to adjourn your case out to that same date, the 12th, so then you can go now. Okay? And that's at 1 o'clock.
Did you already sign something?
Over email.
Have a good holiday. Here on Vista Apartments versus Monica Drummer. Oh, boy. I didn't mean to say it already.
Good afternoon.
I did not mean to say it that way.
Yes, you did. You forgot you was on mic. I heard you. I heard you. How you doing, Judge?
I'm doing well, Miss Drummer.
That's good.
Okay, so what do you have as her balance?
2213.
Yeah. Okay. So I've been going back and forth with Section 8. So after this hearing, I think they're going to reinstate my Section 8. They did pay they did pay 17 something towards last month. They made a payment because I got a receipt number, the check number that they made the payment last month for $1,700.
I missed all of that.
She said her Section 8 is being reinstated and they made a payment in August of $1,700. But
yep.
I don't have the check number for a second. I had to pull it up.
I got it.
That's okay. He has it.
they paid 17, 18. It was credited on the first.
Okay,
Oh, no, that's sorry, it was credited on the fourth.
got it. Okay, so how's this balance gonna get paid down, you believe? Cause you said you were gonna pay 1,000 by the 23rd and I don't have it.
I didn't have it neither. I'm working on it right now though. So give me a couple of days. I can get something into the office because she told me once I pay something, they'll put me on a payment plan.
Okay, then here's what.
Section 8, reinstate my Section 8.
Okay, so here's what I'm gonna do then. I'm going to find no tribal issue after a hearing in this case. I'm gonna grant them a judgment for possession, so we lock in that figure, because if we kick into August, this figure's gonna keep going up. So for the 2213, I will extend the.
Is
grid
that
date
minus
out.
the 17 that they paid?
Pardon?
Is that minus the 17 that they paid? Because they paid
They
17, my
they
actual rent
already
won't be but
they-
233.
They already took that off of your account.
Oh, okay.
Okay. So a writ won't issue until the 12th. So what I'm doing is I'll allow some time. You get that payment in so you can get on a payment plan if that's what they're gonna do. Okay?
Okay. Gotcha.
All right.
Could I add that the judgment may be set aside with a COD?
Yes. Okay. You understand that? So that if you make the payment, they go into a payment plan, they'll set aside the judgment. And then it'll be a conditional order dismissal that you'll enter into.
Okay, gotcha.
Got it? Okay.
Got it.
Fantastic.
All right. All right.
All right, Ms. Drummer. You have a great holiday.
You as well. Thank you.
Thank you. Huron Vista versus Hiantra Hawkins.
Anything for the plaintiff?
She's in Zoom. Ms. Hawkins? Oh, there she is.
But I don't know how to turn my camera on. Is it on? Can you see me?
It's on. We can see you. Yes, ma'am. All right.
Looks like she's on a payment plan. We just need to reduce it to writing. Does that sound right to you, Ms. Hawkins?
Reduce it to what?
If you're on a payment plan, they just have to put everything in writing.
Yeah, well, she wrote out something for me and we both signed it. So, I mean, I don't know if it's more that they had to do.
There probably is, certainly for the court.
Why don't we adjourn it 2 weeks and just see if we can get it done?
All right. So what I'm gonna do is I'm gonna put you out to the 12th, September 12th, 2025. 1 p.m. And hopefully we'll have everything in writing and can get it done. Okay?
I gotta put in another order for it to be virtual.
See, y'all playing me.
Told me it was gonna be put in for the COD today, so I thought it was gonna be dismissed today.
I've done my job. Everybody else is, I don't know what's going on. Fine, Jan.
Thank you.
Just because she doesn't want to write something and put it down and bring it to the court. Fine. All right. We'll allow it next time. Hopefully we can get everything done. Okay?
Right. Have a good weekend.
You too.
Thank you.
New Park Ridge Apartments versus Tiana Sell.
Hello.
Hello.
Hi, Judge. How are you today?
Hello. I'm doing okay. How are you doing?
I'm doing okay.
All right. Let's see. And how much did he go? I had 6,235 last time we were here, but there's a recertification issue or something.
Well, she now owes 6,240.
Okay. Is there a recert that's?
I see where she said that last time, but I don't have anything here that says that. Let me just look at her ledger and see if there's anything unusual there. Nope.
Ms. South, what do you believe the problem is with your research?
Your Honor, I was told when I went into the leasing office June that I supposed to be start paying rent in February. Nobody notified me, no certified mail or anything. That's why the bill is so high that I was even supposed to be paying rent until June. So I am trying to get help with that. I don't believe that I owe the full balance that's due, that they're saying that I owe. So I did go to DHS, try to get help with that. Had an in-person meeting with my caseworker for the SCR. So I am gonna be able to get help with that. I go meet with Hawk on the 22nd of next month. I think the problem is they gotta bring down the balance in order for to assist me and to help me because it's so high.
Right. The other thing is, well,
And I am back at work full time. So on the 12th, I mean, I don't know if you're gonna adjourn it to the 12th, but I can have 1,200 paid to try to bring it down some.
but that's still, how much is your monthly rent at this point?
It's my monthly rent, what they told me when in June was $780. If I'm not, hopefully I'm correct about that.
788.
788. Okay, so the problem is that if I adjourn it out, this is gonna go over 7,000
Okay.
on this, right? So here's what I'm gonna do. I'm gonna find no tribal issue after a hearing. I'm gonna try to freeze this number
Okay.
and gonna grant a judgment for possession and issue the judgment for that amount. But a writ, I'm gonna give an additional week on the writ to the 15th of September. And so what you gotta do is you gotta work there, see if your Hawk appointment can get moved up. So that, you know, see if your Hawk appointment can get moved up.
Okay.
Okay. And let them know that, you know, you've got a deadline of the 15th and see if they'll do something else for you, okay?
Okay.
All right. Okay, thank you.
When do I come back to court, Judge?
I don't have another date. You don't have another date to come back to court. You get to work with them to try to figure this all out.
I think we're gonna need more time than that, Judge. If I could please get some grace with this.
Well, I don't mind giving you grades, but something's got to get paid on this. So
I can try to at least give you 2,000, Your Honor. You can give me time on the 12th.
here's what I'll do. I'm gonna add under here that if 2,000 is paid on September 12th, 2025, then how much more time are you gonna need?
Hopefully they'll bring it down then. I'm gonna call, like you said, to Hawk again and try to get more resources so I will have a better answer for you when I come back in.
Your Hawk appointment is the 22nd, right?
Yes.
Okay, if you give 2,000 by the 12th, then I'll extend a writ date out to the 24th. And that way you can tell Hawk that.
Okay. All right, Your Honor.
Okay,
Yes, Your Honor.
okay, thank you.
All right, thank you.
Calls the case of New Park Ridge versus Marie Richardson. Not checked in. You've been sworn. If you'd like to proceed, you may.
Thank you, Your Honor. This is an action for non-payment of rent. This defendant owes $1,545 in rent. The costs are $176. We request a default judgment for possession only in the amount of $1,721, possession only.
All right, judgment to the plaintiff. That's by default for possession. Redemption amount is in the amount requested with the writ to issue in 10 days. New Park Ridge versus Melinda Ostrander.
James Fink for the plaintiff. Her total is $908.
908.
Yes, 908, sir.
Hello.
Hi.
All right. You owe $908. When do you think you can get that paid?
I,
Okay, hold on. Who's here with you?
my social worker from,
Okay, do you have a problem? I'm not gonna have a problem if she helps you out trying to do this, okay? Would that, you'd like that? Okay, all right.
Your Honor, it said 908 is 980.
980. Okay.
check they just received. Same. It's supposed to be 780 because 200 came in today.
All
From
right, so
Deepa.
I'm sorry,
It's
you paid 200 came in today
on the 28th. On the
on 28th?
Yeah.
To their office?
Yes. I have the ledger too. You should get the paperwork right here.
Okay, all right. They just may not have that number yet, but, okay, so 200 went in, so if we're at 780, how do you think you're gonna get that paid? Do you know?
I've been working with CMH and the social worker there said she could help me with a couple of different places.
To move?
No, to pay the,
Oh, to look certain places to try to get it paid.
yeah.
Okay, did they give you an indication of how much time that would be for you to do that?
Ipsy.
It looks like she was gonna meet with DHHS last week.
I got denied.
All right.
But the social worker at CMH, she said she'll help me with the other two places. And if in Ipsy thrift store said to make the request on 9/3.
Because they'll get the
2 weeks.
Yeah. All right, what I'm gonna do is I'm gonna adjourn your case out 2 weeks to September 12th.
I have a question.
Okay, go ahead.
Can we waive the fees,
The,
late fees and court fees?
well, I don't have in front of me how much that is in terms of late or the late fees. So you'd have to talk to your landlord about that. If we get close enough, I'll look at trying to do something in terms of giving more time to get those court costs paid off, so you're not gonna be out of your place, okay? That's about the best I can do, but in terms of the late fees, you'll need to talk directly to the landlord. Okay? So we'll see you on the 12th at 1 p.m.
Okay.
All right, thank you. Peninsular Place versus Jacqueline Gardner. Said that right.
Hi,
Hello, Miss Gardner. How are you?
good. How are you?
I'm doing well. She better have that baby.
You got a shield.
Okay. Oh, hold on. I was looking at the baby. I don't want to talk to you. Oh, look at this. All quiet, shouting, little eyes open. Okay. Now I'm good. All right. What were you gonna say, Mr. Fink?
Forgot.
This says, Miss Gardner was going through a very stressful time during her pregnancy. She lost her job. There was a whole bunch of stuff going on.
Yeah.
And then she gets to try to get help. Not like she doesn't want to work, she can't. And she looks to try to get some assistance, but she doesn't have income, they wouldn't give her assistance, and they wouldn't give her assistance because she didn't have a job and could, so.
Somebody paid $32.91 on the 15th.
Yep, and I paid the final balance 3 hours ago.
Yeah, I know they paid it down. We got it paid down, and then you did what? You paid the balance off?
Yes, at 12 noon today.
Okay,
Was it 866.83?
Yes, I paid $868. So extra $1.
okay, so.
Why don't we
you
adjourn
don't-
the week and
Yeah.
I'll confirm that she got to zero, and if she didn't, at least we'll save her court costs for a.
Yeah, okay, so here's what I'll do. I'm gonna adjourn it out 1 week to the 5th, 2025 at 12 noon. And that's just so that the payment can catch up,
Okay.
okay?
Ms.
And
Gardner,
then-
you could check with my office on Wednesday or Thursday to make sure that we confirm that it was paid.
Mhm. Okay.
Okay,
And if it was paid, we'll dismiss the case.
and you don't need to appear. I
Okay.
should make you appear and bring the baby, but I won't do it. All right, Ms. Gardner, it's been a
Thank you.
pleasure. And hopefully everything's all paid, and then I won't get to see you and I won't get to see the little one, but you two take care of each other, please. Okay?
Thank you. I appreciate it.
All right, bye-bye. Court calls the case of River Ridge Apartments versus Jason Pennington. You guys, see, did you see him back there?
Yeah, we were like contemplating.
Because every case I call, she would lean forward like it was her. Did you see that? She did it like 4 or 5 times in a row.
She didn't even get here till 3:30.
I don't know what she got, but she.
She needs to watch the video.
she
Was it
Listen.
over 3,000 right now? Is that what we got?
3,092.60.
Okay, I can pay 500. I talked to the office about setting up a payment plan each week because now I work 2 jobs and I make too much to get a government assistance now. If they want me to vacate the apartment, I already talked to my public defender. I already talked to Brian Levette about the steps that have to be taken in order for me to be moved to another apartment. It just all takes time. But I know they want the apartment back. I understand that. I'm not
Okay.
gonna be bitter, about
Okay,
it.
so here's what I'm gonna do, at least freeze this number. And I know he has a tether issue, so he's gotta get that
Oh, I remember this.
moved around. So what I will do is I'll issue a judgment for possession, finding no tribal issue after a hearing in the case. And you
Okay,
said it was 3,092.
yeah,
It's 2842.61 plus 250 in costs.
I mean, I did try to reach out to the
The
office,
total amount is, I'm sorry,
3092.61.
got it.
and I don't mind paying $250, $300 a week. I don't have a problem with that, but I understand.
We're not offering a payment plan on this one, Your Honor.
Okay, so I'll issue that judgment for that amount. Because of the other issues you got involved, Rich issued the 12,
Okay,
okay?
okay. Well, I'm planning on vacate the apartment probably at the end of the month because that's probably what they're gonna force me to do. So I'm already in that transition of making, letting her clean the apartment, make sure everything is nice and clean before I surrender the keys, but all that takes a little bit of planning,
Okay,
a little timing.
good. All right, you're all set. Good luck to you, Mr. Penn.
All right, thank you.
You know what? As much as she was rocking back and forth, I'm gonna not call her case. I'm gonna call everybody's case but her. Is this the one you set her case out? To call her next? Why? No, you should have, did you see how she was acting? She didn't, oh, you don't know. But
She does not. Are you for Bruce Williams?
No, Jamila Williams.
Oh, okay, all right.
that's what you put up here. I'm not. She was just rocking back. Did you see her? Ann? Yes, you can. Court has called the case, People versus Jamila Wilson.
Williams.
Williams, excuse me.
And her total is $2,402.
2004. And how are you gonna get that?
The last time I was here, I signed up for the COD. And I think it was approved by my landlord. She told me that she was gonna approve it. And she said when I came to court today, that I probably would just have to sign something to.
Because we need a COD drafted.
Okay.
Why don't we adjourn it?
Can I get a video, Zoom or something?
The way you acted today, no.
Come on.
No, I'm gonna see if you
look,
can sit in
I'm
the
working with you.
Give me your
Okay.
email,
Huh?
put your email address right there.
I don't check my email often, but.
Then don't bother.
Right, you might want a phone number.
How are you gonna sign a COD if I get you one?
Give it to can you give it to landlord?
Who?
Ballard, Tanisha Ballard?
Yeah, she'll get with you.
Mm-hmm. She'll get with me.
Are you guys done? Because I'm still here. No,
I'm sorry.
September 12th,
I gotta come back.
2025. What?
I work 7 to 3:30.
What time? 1 o'clock. So just listen. If you get that COD signed, I understand they're trying to do whatever, but if you get that signed, then you won't need to appear. I'm just gonna advise you at this time.
Okay.
That you would have 3 business days from the signing of the COD to move to set that aside.
Okay.
Okay. If some right you haven't asserted, some misunderstanding or anything like that.
Okay.
So if you get it signed, then this could all work out for you.
And I'll have to
come back. You don't have, you just look at her.
I'll be at work.
You don't have to come back and act up in my courtroom like that, like I call a case. And you know what? I was calling case, they're not even her apartment complex. She would.
So, see, were you
I work
inmate
at the
of
women's
month?
prison. I work at the women's prison.
Or were you inmate of the month?
I'm not an inmate, what?
Okay, as long as you have a great weekend.
Thank you
Good
too.
holiday.
Do I need to? Just wait for.
Just wait for my email.
Copy that. I'm not gonna get it.
She gonna mess it up.
Thank you.
Thank you. Strong Future Homes versus Bruce Williams.
James Fink for the plaintiff.
Mr. Williams is not here.
All right. Go ahead.
Your Honor, this is an action for non-payment of rent. Mr. Williams owes $63. The costs are $176 for a total of $239. Request a default judgment in that amount. I will add underline 10, no writ without a hearing.
That is correct. Judgment to the plaintiff, that is by default for possession.
I'll also add set aside if paid.
Okay. Judgment will enter in the amount requested, embarrassingly so, but it will. With a writ to issue in 10 days, no writ without a hearing, judgment will set aside. Yeah. Oh, and that was a great one to end on. Evergreen Apartments versus Agarulia. Southside versus Deion Brown, Strong